Guarantee Association. And I see Mr. Biasotti. Good morning, sir. And I see Ms. Tut. Good morning, ma'am. So what I'm gonna ask you to do, Ms. Tut, to mute your microphone while Mr. Biasotti is making his argument. And Mr. Biasotti, you do have 20 minutes. And if you'd like to reserve up to 5 minutes for rebuttal, let me know. I've got my clock ready to proceed right here. So whenever you're ready, please proceed, sir. Okay, Mr. Biasotti, I cannot hear you, sir. I cannot hear you. It looks like you're unmuted, but I cannot. Okay, now you're muted. Let's unmute you. Okay, try now. Okay. No, we cannot hear you. I could see your mouth moving, Mr. Biasotti, but there's nothing coming out. I tell you, if there's a concern, the numbers that I think our marshal had provided you at the very beginning, perhaps we could proceed with the audio as opposed to the video. All right, sir. Mr. Biasotti, I've just been advised by my marshal. Would you like to see if you could leave Zoom and come back again? And maybe when you rejoin, it could reactivate everything? Try that. All right. Actually, it's been going very well so far. This is the first little technical glitch we've been having, so. All right. And he has not rejoined yet. We're still waiting, Ms. Todd, just to keep you advised. Let's see if he rejoins right away. And if he doesn't, we may need to take a break to make sure that we could get him back, Ms. Todd. So hang on right now. Okay. Okay. Okay, so then let's do this, Ms. Todd. That way, I don't keep you hanging on. I'm gonna try to see if my marshal and my folks could see if they could get Mr. Biasotti. Oh, here we go. I see him. He's connecting to audio. Wonderful. Mr. Biasotti, can you hear me, sir? Okay, now you're muted. Mr. Biasotti?
Can you hear me?
Absolutely. Now we can hear you, sir. Well done.
It was, for whatever reason, when it came out, it said my microphone, it changed microphones. I don't know what that means.
And so just, you know, Mr. Biasotti, I can hear you perfectly. If it's your intent to show up by video, all you need to, there you go. Now I could see you. And could you say something real quick, just to make sure I could hear you?
Good morning. Nice to see you.
Wonderful. All right, Mr. Biasotti, we're ready to proceed with your argument. You may proceed, sir.
Thank you, and I apologize for this mix-up. May it please the court, my name is Robert Biasotti, and I represent David Rodriguez. I'd like to please reserve 5 minutes for rebuttal if I could.
Very good, sir.
We're here on the appeal of a summary judgment entered in favor of FIGA, and there are essentially, at this point, 3 issues on appeal. One is prevailing party costs. One is prevailing party attorney's fees that we think Rodriguez should have prevailed on summary judgment. And the second thing is, if there are any issues in this case, FIGA shouldn't prevail on summary judgment. And let me just give you short background facts. In 2009, Rodriguez suffered a sinkhole in his house. His insurer was HomeWise. The records of HomeWise demonstrated that in order to repair a sinkhole, the repairs exceeded the policy limits. That caused a problem for Rodriguez, but it also caused a problem for FIGA, because FIGA repeatedly over the 5 years or up to 5 years of this appeal, FIGA said, as it says in its brief, we're a creature of statute, and they're powerless to rewrite Chapter 631. Well, in this case, that turned out to be not true. FIGA went to the receiver for HomeWise, just this insurance company, not all insurance companies, HomeWise. And the receiver court issued an order saying that FIGA could exceed the policy limits in order to repair sinkholes. And in this case, that happened 5 or 6 years after FIGA took the case.
Can I talk to Mr. Biasotti? Because if I may just kind of, and we're familiar with the history, and as you know, Judge LaRose and Judge Rothstein, everybody reads the record. I've worked with them before. Everybody's very familiar with the fact. Our court has ruled, in fact, both Judge LaRose and Judge Rothstein were on a case of Hyde versus Florida Insurance Guarantee. And it seems to have addressed the very same issue. It seems right on point with this case. Could you tell me why it's
this is
different and why we should not follow it? And not only that, there's also another case that came out last week that Judge Northcutt authored, which is the FIGA versus Valdez case. So I want to give you the opportunity to address that for me right away, Mr. Biasotti.
I didn't see the recent case, but let me just talk about this case. The trial court, in his order granting summary judgment for FIGA, made findings of fact. And this is at record 1632. There is no questions that delays occurred in this case, and certain positions taken by FIGA, such as stating it would not pay over the policy limits, were later reversed. That's a finding by the trial court. Second, the finding by the trial court. Both parties agree that damage claims have been satisfied by FIGA over and in excess of the policy limits. I guess there are 2 questions. There's no question that his property has been fixed, and it was fixed over the policy limits, and it finally got paid for in 2018, 7 years after FIGA got the case. No question of my client's property is fixed. The question is, for costs, who becomes the prevailing party? I mean, FIGA said for years and years and years they would never pay over the policy limits. They did pay over the policy limits. Even if we're not entitled to attorney's fees, put that aside, how could you not consider Rodriguez a prevailing party when he got his property fixed? In the answer brief, FIGA stated, well, Rodriguez only wanted money for this case. That's not true, and it's proved by, we said in our brief, by what he said in his complaint. He wanted his property fixed. And the statute, 631-54-3C, if nobody finds it, if has found it unconstitutional, it certainly ought to. Because if somebody has a sinkhole and they have $200,000 worth of insurance and it costs $300,000 to fix it, what's going to happen? Well, what's going to happen now, if it was HomeWise, is FIGA will fix it for $300,000 based on an order by the Leon County Circuit Judge in the receiver case. It has nothing to do with statutes. It has nothing to do with Chapter 631 or 631-54-3C, which says, because that's still the statute. 631-54-3C still says you cannot pay over the policy limits. So if FIGA is a creature of statute, why does that statute not apply in this case? And why did they go, which is a good thing. We don't disagree that FIGA was in the right. They went and got these sinkholes fixed where they were over the policy limits. The statute is wrong. The judge was right, the judge in Leon County. I'll tip my hat to FIGA because they are now fixing sinkholes for only HomeWise over the policy limits when you make a check to a contractor. But at the end of the day, Mr. Rodriguez, from day one, to fix his policy at the lowest limit, exceeded his policy limits. No contractor will write a contract to say, I will fix your property for less than what it costs to fix. It's just not going to happen. So you can never get a contract that they're going to fix the property if to fix it exceeds the policy limits. FIGA's benefit, or the good thing that FIGA did, was they actually went to court in 2015 and got it fixed. The problem in this case is that in February 2015, they got an order, which is in the record at 1660, which said they can pay over the policy limits to fix sinkholes for HomeWise insureds. Then the problem is the next month, FIGA sent in a hand-delivered letter to my client saying, we will not fix your property for over the policy limits. So they never, the only reason that Rodriguez knew about this statute, about the order that FIGA received for HomeWise, is they filed it in this case on page 1661 in 2019, long after the property was already fixed, long after everything was done. So, I mean, putting aside, I don't want to say put aside the legal stuff, ask anyone on the street if they think Rodriguez is the prevailing party. He got his property fixed for over the policy limits in contravention of the statute. And the FIGA's was good enough to get an order that said that. Sad that they didn't share that order with us at the time and tell Mr. Rodriguez, just enter a contract for any amount of money that we approve of and we will fix it. And that's what they did. And they paid substantially over the policy limits. Now, to FIGA, in this case, it was maybe $20,000 over the policy limits. The FIGA is like, well, 20,000, that's not that much of a money, not much of a big amount of money. And yeah, we got an order in 2016 that we could pay for policy limits, but we didn't disclose that to you for 3 years. Rodriguez finally, in this case, and which FIGA has done routinely, is they say, we will not fix your policy unless you drop your appeal, which they did in this case. We gave them an insurance policy, a signed contract. They refused to honor it. They said you have to drop your appeal. We didn't. We went into court to do a motion to compel. And on the eve of the motion to compel, FIGA said, we'll fix it. So I'm certainly aware of all the cases that were cited in this case. I'm certainly aware of the De La Fuente case because I argued it. I'm aware of the other cases that were cited that the trial court listed in his order. which is at 1632. He lists several cases. But it's just that order on its face is incongruent with the facts. The judge said that there were questions of delays, and that FIGA actually fixed the things. Let's see, 2018 was the last payment they made. For 2011 was when they took the case. 7 years. They got the contract from us in 2016. They finally paid for it in 2019. 3 years. They stalled the case throughout, saying dismiss the appeal or we won't go forward. There's a finding of fact that they satisfied it in excess of the policy limits, and they took positions that they later reversed. Now, I'm not sure that those facts are in all of the other cases. I'm not sure that they had the benefit of the HomeWise order, which is in this record, that the receiver for HomeWise got, and allowed FIGA to ignore the statute. But in this case alone, are we saying that on the Florida summary judgment standard, which of course is a very, very difficult standard, that FIGA was the prevailing party by paying over the policy limits after they repeatedly said they wouldn't? It really doesn't make any sense. That's the second question. There are two questions with regard to whether Rodriguez should win summary judgment based on this case, at least for whether he's the prevailing party for fees under section 57041. There's a different thing for whether he's entitled to attorney's fees under 63170. And we believe that 63170 and 61543C can be read in together, particularly in this case where FIGA completely ignored 631-543C. That was not part of this case. They paid over the policy limits in contradicting the statute that they are to enforce. And the question is, you'll see it all over the place, all over this record, because they say, well, we did not deny by affirmative action, payment for this claim. Well, come on. They said they refused to pay it over the policy limits for 5 years. My client could never enter a contract to get this thing fixed. FIGA acknowledged that problem, not with just my clients, but clients all over who had contracts and proposals and neutral evaluations where it exceeded the policy limits. And an important fact in this case, which maybe we didn't really make a big deal out of it in the brief, but I kind of think it's important. FIGA never did a neutral evaluation in this case. The neutral evaluation was done by HomeWise in 2010. HomeWise did a above the ground estimate in 2009. And FIGA relied on that 2010 report from the neutral evaluator. The problem is that in 2011, when the statute changed, and that's the statute that runs this case, as everyone knows, they also changed the statute for neutral evaluation. And the neutral evaluation case in 2011 says the neutral evaluator is supposed to do the above the ground and below the ground in his report. That was never done in this case. There's nothing in this record other than the things that we got out of HomeWise files, same thing that FIGA got out of HomeWise's files, that there is no way that Rodriguez could enter a contract with a licensed contractor to fix his property, to fix his sinkhole. And so he lived with a sinkhole for 5 or 6 years. FIGA finally came around. I used the word confessed judgment. I know that offends everybody, but they did pay over the policy limits. There's no question about that. The trial court found that in the order granting summary judgment.
Mr. Biasotti, now you're about to get into your rebuttal, sir. Would you like to reserve the rest? You have
Yes,
5
please.
minutes left. Very
Yes,
good.
I'd like to reserve the rest. Thank you.
Thank you, sir. All right.
Do
And,
I,
if, and I want you to mute now yours,
I hope I come back, please.
and hopefully you'll come back. Excellent. All right, Ms. Tutt, you may proceed, ma'am.
Yes, good morning, Your Honors. Thank you. Diane Tutt for FIGA. The trial court correctly entered judgment in FIGA's favor, addressing first the issue of whether Mr. Rodriguez should have obtained costs. Is very clear from the case law that if the judgment stands as it's written, which is a judgment for FIGA, Mr. Rodriguez is not entitled to costs. There's a few cases that we cited, including Thatcher versus Matthews. In that case, the plaintiff had actually gotten a judgment, but after some set-offs, ended up with zero. So even if this was a money judgment request, etc., Mr. Rodriguez did not get a judgment in his favor, so he's clearly not entitled to costs. But I perceive that to be a rather minor issue. I think it's clear that this case, as admitted by Mr. Rodriguez's counsel, this case is about attorney's fees. And what I want to start with here is a discussion of what this claim against FIGA was. Mr. Biasotti in his reply brief did not really accurately state what the amended complaint alleged here or sought here, and I just want to go over that. The amended complaint is at 141 through 145 of the record, and I'm going to read a couple of paragraphs from that because it makes it clear that the plaintiff, when he sued FIGA, was not looking to get payments made to his contractor. He was looking to get payments made to him. Paragraph 12, plaintiff is entitled to insurance proceeds as a result of a covered peril. Paragraph 17, FIGA has a duty to indemnify the plaintiff in the event of a covered cause of loss during the policy period. Paragraph 18, FIGA breached the policy by failing to pay the plaintiff the benefits due and owing under the policy. The wherefore clause, plaintiff David Rodriguez demands a judgment against FIGA for damages and some other things. So it's very clear that this complaint, this amended complaint, it essentially tracked the original complaint, which had been filed against HomeWise before its insolvency. It's very clear, not only from the reading of the complaint that I just gave to your honors, but also from the course of conduct in this entire admittedly long case by the plaintiff. It is quite clear, based upon the appraisal that they sought and their opposition in the appellate courts, both in this court and an attempt to seek Florida Supreme Court review, that the plaintiff was fighting tooth and nail not to have section 631.543C, the 2011 amendment, fought very hard not to have that statute be applicable. And that statute changed the definition of covered loss for FIGA in a sinkhole case. And it made it clear that payments were not to be made directly to the homeowner. And the reason for that, is shown by the legislative history, is that the legislature was concerned that homeowners were not repairing their homes and were taking insurance proceeds and just walking away. And I know that in a variety of insurance contexts, sometimes insureds take the money and do not make repairs. But when we're talking about sinkhole damage, the legislature obviously did not want a bunch of houses that could never be, lived in, because they would get worse and worse, and there would be no shoring up, et cetera, of the problem. The legislator wanted to prevent that. So the plaintiff's goal in this case was not to get payments made to his contractor. It is just the opposite. The plaintiff's goal, as clearly set forth in the complaint And in the proceedings in the case, as discussed in the answer brief, the goal was to get this statute thrown out. And the argument basically, in a nutshell, I know there was a lot of arguments, but basically in a nutshell was that the statute couldn't apply because it wasn't in effect on the date of loss. This court rejected that argument in the De La Fuente case and cited De La Fuente when it reversed in our case. And the Florida Supreme Court adopted that rationale in the De La Fuente case. So it is given law, and the plaintiff should not now be arguing that that statute is somehow, quote, incorrect, which I believe Mr. Biasotti said during his argument. That statute is the law. It controls here. And it's important because even though that's not the issue before the court, the issue is attorney's fees and who gets a judgment. But that statute is important because it sets forth the rationale that the plaintiff here was trying to get around. And yes, there were a lot of delays in this case. Mr. Biasotti indicated that the case started in 2011 and the repairs were not finished until 2018, but he neglected to advise, Your Honors, that the plaintiff did not provide a signed contract with a contractor to FIGA until July of 2015. Payments to the contractor commenced in October of 2015, and the repairs took a little over 2 years. So they were concluded in either 2017 or 18. So the delays in this case, and frankly, I don't even know why we're really focusing on delays, but because the attorney's fee statute 631.70 says delay does not give attorney's fees to a claimant. And as I believe it was Your Honor pointed out, the Hyde case says that 631.543C itself says there are no attorney's fees entitlement to the as a result of these sinkhole losses. Frankly, we had not raised that argument. I don't think we need to. I think that even under 631.70, the plaintiff cannot be awarded attorney's fees because they did not prevail in the action that they set up, which was a payment to them. Or when I say them, I mean Mr. Rodriguez. They simply did not prevail on that count. And that was the only claim in this case. Secondarily, as 631.70 says clearly that you don't get attorney's fees against FIGA unless it has denied coverage by affirmative action other than delay. There was never any denial of coverage here. Before FIGA got brought in, it sent a letter to Mr. Rodriguez indicating that it would pay his covered claim pursuant to the statute. That principle of coverage, acknowledgement of coverage, was set forth clearly numerous times in FIGA's answer, relying on the statute. In his initial brief, Mr. Biasotti indicated that that was a, quote, conditional coverage acknowledgement, but there was nothing conditional at all. FIGA said it was accepting coverage. Now, it stated the statute because we wanted to make clear that that's how the payment had to be made, but there was nothing conditional at any time about FIGA's acceptance of coverage. So therefore, even if 631.70 is the basis for a claim for attorney's fees, the plaintiff must lose on that because there was no denial of coverage. The other argument that Mr. Rodriguez has made is that, excuse me. All right, apologize, Your Honor. Had a little technical glitch.
No
What I
problem.
was about to say was that Mr. Rodriguez has argued that because FIGA ended up paying above policy limits, that somehow when FIGA originally said we cannot pay above policy limits, that was a denial of coverage. Well, frankly, that makes no sense whatsoever. That was a statement of coverage of a limited amount of coverage. So the original statement that we can't pay the benefits, or we can't pay the contractor above policy limits, is not a denial of coverage. It's a reaffirmance of the limits of coverage. Now, fortunately, the receivership court allowed FIGA to make some payments above policy limits in these HomeWise cases. That certainly inured to Mr. Rodriguez's benefit, and we're all very happy that that happened. Mr. Biasotti is arguing that, well, Mr. Rodriguez could never have entered into a contract above policy limits. Well, where's the evidence for that? People have a certain amount of insurance coverage. There are times when the damage exceeds that. And the insured sometimes has to add to the coverage to get the repairs made. That's a common situation. There's no evidence in this record that Mr. Rodriguez was financially unable to do that. The final thing I wanted to mention is that the request for attorney's fees here it simply just does not jive with any of the case law. Unfortunately, I did not see FIGA versus Valdez that was mentioned. I just tried to look it up while Mr. Biasotti was arguing, so I don't know what that said. But the existing case law out of this court and other courts have held that, for example, Florida Insurance Guarantee versus Smothers, that's a fourth DCA case. That court said, if there's any kind of dispute over the amount, in that case, FIGA ended up paying more after suit than they had before suit. That's deemed to be a dispute or an issue over amount, not coverage itself. So at most, what we're dealing with here when we say FIGA said we can only pay up to policy limits and then ended up paying more than that, that's potentially a dispute over amount, although that was never really a dispute. But the Smothers case says that is not a denial of coverage. Similarly, the Miller case out of this court says that raising affirmative defenses is not a denial of coverage. FIGA's affirmative defenses in this case, there were 3 of them. And it basically said, we are covering this loss, but pursuant to the statute. The cases are legion that that FIGA is not an insurance company. It is a legislatively created body that has limitations that are pursuant to statute. It simply does not step into the shoes of the insurer. It's not entitled, it's not required to pay attorney's fees under 627.428 like insurance companies. It is limited. And attorney's fees is a big part of the limitation that the legislature has imposed in these cases. And FIGA would urge the court to fully affirm the trial judge's ruling because there are no issues of fact here in dispute. The statute is clear that you have to have denial of a covered claim by affirmative action. There's not one iota of evidence presented by the plaintiff below to suggest that that would be a question for the jury. So we thank you for your time and we would ask you to affirm.
Thank you, Ms. Stephan. I'm going to ask you to mute your microphone at this time. And then Mr. Biasotti, please, excellent. You're unmuting it. Wonderful. You have your rebuttal time. You have 5 minutes, sir.
Thank you, Ron. First of all, Ms. Tutt made several things about evidence. We're on summary judgment. I almost am afraid to say what the standard for summary judgment is. There can be no factual disputes or any possibility of factual disputes before you get summary judgment. Second, this case, when the trial court entered the order 10 years or 6 years later, Rodriguez put in his contract. They sat on it for a month, called him again. They sat on it for another month. sat on it again. They sent us a letter that they will not do anything until we drop our appeal. And this is all in our facts. We did a motion to compel, and at the last minute, they agreed. Ms. Tutt kind of poo-poos, well, that was just 3 or 4 months out of this whole case. No, it isn't. And I mean, I don't want to beat the dead horse, but Section 631, paragraph 3C in 2012, and since then it's changed. But C3 says, the association may pay for actual repairs to the property, but is not liable for amounts in excess of the policy limits. The policy limits were $177,000. They paid $196,000. So they did not comply with the statute. There's no question about it. And we're happy that they didn't, because Mr. Rodriguez would never have gotten his sinkhole properly fixed if they did not exceed the policy limits. But listening to the story about other people and attorneys trying to get rich off of these things, this is not that case. I believe Ms. Tutt said that we misrepresented in our reply brief. I encourage the people to look at our reply brief. We said in the reply brief, in paragraph 21, Rodriguez states, quote, plaintiff seeks the complete repair of his property in its entirety, included but not limiting to ground stabilization, building stabilization, foundation repair, and cosmetic repair. And the reason at the time that we sought appraisal, which now is not available, and the reason we sought money, because we couldn't get around this thing, is that no contractor would ever enter a contract to repair something when it costs more to repair the property. And she says there's no evidence of that. Maybe there certainly is a suspicion that there's evidence of that. If she'd like, I'll get Mr. Rodriguez to come in and say he can't sign a contract because he doesn't have the money. That's almost common sense. Ms. Tutt, and she does an excellent job. We were against each other in this very case in 2013 when I raised all the constitutional problems with this thing. She said it went to the Supreme Court. That's true. Supreme Court didn't take them because she filed the order at the Supreme Court where they said they could exceed policy limits. That's why the Supreme Court didn't take it. But in this case, I'm sorry, this is different. At every time, and even to this day, FIGA states they followed the policy. They followed the statute. They did not follow the statute. The statute says...
Sorry, you have 1 minute left. Just want to keep you on track, sir.
Well, to be fair, at the very least, we think the record is clear and we should win on both things, fees and costs. But if not, if I'm wrong, then tell me why we're not entitled to have a trier of fact determine this. The trial court originally found that. FIGA moved for a hearing. The judge flipped on it. We think that was wrong. We think this court should look at that and at the least reverse the summary judgment for FIGA when they paid over the policy limits in this case.
All right.
Thank you.
Thank you, Mr. Bisani. Thank you, Ms. Tutt. You also survived a virtual remote argument. So thank you both. So at this time, what the court's going to be taking a 10